Hi and welcome. My name is Susanna, and we have a very special and incredible episode here at Lights of the Round Table. It is our honor to have Loy Brunson as our guest today. Loy and his brothers are in the midst of making history in support of all of us. Do you want to hear what it is? It's an incredible lawsuit that has just been docketed at SCOTUS, the Supreme Court of the United States. And this may just give SCOTUS the ability to remove the upper echelon from federal office positions for not investigating election fraud. An incredible story where the courts were being used to block the lawsuit until something miraculously broke loose. Loy, welcome. This is truly a story of patriotism and determination. Tell us about your case.
Thank you, Susanna. It's a pleasure to be here.
All right. Well, when did you start this path? When did you actually come up to do the lawsuit of the century? I don't even know if it's called the lawsuit of the century, but explain to us, how did you ever got together and decided to go this path?
Sure. Well, a little background information. My brothers and I are known as the Brunson brothers. And back in the day, many years ago, we got on a bunch of national television shows, Tonight Show, Johnny Carson, a bunch of stuff like that. So after we kind of ended doing that, we just started getting into the Constitution, and which led to about 2 years ago, we thought we've got to do something about this 2020 election. There was just so much questionable stuff going on. And so we decided we needed to file a lawsuit. My brother had been in lawsuits before, and he's not an attorney, but he had actually sued some banks having to do with the the subprime mortgage problems that caused him some problems. And so he decided to start suing some banks, which he did, and he had some success with that. And so he had gone to the Supreme Court twice up to this point, and he had litigated in state and federal court as a pro se litigant, which means he did not have an attorney. He did it himself, for those of you that don't know. And so he's decided we need to do something. So he called me on the phone. He says, I have an idea to file a lawsuit against all those who push back against a simple 10-day investigation. So this lawsuit would not be about the outcome at all. It would be about defending my right, our rights to participate in an honest and sound election, regardless of who won. So he asked me if I'd be the plaintiff because he likes the way I speak and present things. So I said, sure, I'll do it. So we filed a federal case in federal court here in Utah. Now, meanwhile, I have another brother that's a really brilliant programmer and fantastic guy, and he was part of our team. And he said, I think it'd be a good idea if I filed a lawsuit as well in a separate court. So we have two going instead of just one. So the goal was to make it to the U.S. Supreme Court. And we thought if we have two opportunities, that's going to increase our odds. So our motive was not to win in the lower courts. We would litigate. We knew they would file motions to dismiss. The U.S. attorneys were handling it. We knew that would happen. So they would file a motion to dismiss, and we'd file an opposition. They'd file a reply. That we'd get a decision from the judge. So we went from state court. They moved it to federal court, which was fine. We're happy with that. They got it dismissed in federal court. It's like, great, as long as we have a decision, we can move forward. If they were to not make a decision, they could sit on it forever and would be stuck. So they made a decision. So we're happy about that. We go to the 10th Circuit Court of Appeals, hoping that they dismiss it quickly. And after several months, nothing happens. And we get together thinking, hey, this could sit here forever. We're dead in the water. And my case was already stuck in federal court. They wouldn't make a decision there as well. So we thought, we got to do something. They made a decision in the federal court, but the circuit court needs to make a decision before we can go to the Supreme Court. So we did some digging, and our legal-minded brother discovered that there's a special Supreme Court rule that if they deem it or if they recognize it as a national emergency and you file it that way under Rule 11, that it's a national emergency, you put that right on the cover. Basically, this is a national emergency. This is a petition for writ of certiorari under Rule 11, which means emergency. And if the court clerk accepts that, then it's on the fast track and we don't need a decision from the circuit court. So we went ahead and filed that, and with our fingers crossed and prayers going, and about 5 days later, we received a phone call from the clerk's office, a case analyst. Now, the clerk of the court is not one of the justice's clerks. This clerk, the clerk of the court for 11 years was the attorney for the Supreme Court. And one of the case analysts called us on the phone and said, we've decided to accept your Rule 11 platform as this being a national emergency. And then they requested that we include additional documents that would help them expedite this in the conference. And so we did that. We were all ready to go. And then the 10th Circuit backpedaled. They must have got word of this. They backpedaled. They made a decision, probably because they didn't want that Rule 11 hanging over their heads where they were not making a decision. So we got on the go. You want to ask?
Yeah, I did want to, if you could, before going any further, can you explain what Rule 11 is? I don't think most people know.
Rule 11 the Supreme Court Rule 11 is a very special paragraph that simply tells you that if you don't get a decision from the final court, which is normally required, you can provide information to that effect and explain why, that you hadn't received a decision, and explain why it's a national emergency, which is part of our pleading. And so we got it to them, hoping that they would accept our position that we want this, to be a national emergency type case. And so they called us on the phone and said, yes, we're going to accept that premise. We're going to accept your Rule 11, so you can move forward with it. And then as we were preparing that, the court is very specific about how they want it prepared. There's a limited number of words. It's got to be pretty thin, and it's got to be a certain format. They request to be perfect bound, so we have to go to the printers and we have to take it to the binders. So we were doing all this, and we were like a few days away from having it bound, and we got a notice from the circuit court that they had made a decision. So it's like, okay, now that they've made a decision, we don't need this Rule 11 part of our petition. So we called the Supreme Court and said, hey, we just got notice from the circuit court that they have made a decision. So should we take it out because we don't need it? And they said, yep, you don't need it. Take it out and make sure you put stuff in that we have requested. And then they said, how soon can we get this? And we said, well, I think we're about 2 weeks away. And they says, oh, okay, but please get it to us as soon as you can. So we put it together in a week, and we got it to them a week before we said we would. It was on a Thursday that we had it overnighted mail to the court. They got it Friday, and on Monday they docketed it.
Okay, Monday, but we're talking October. We're talking October 26th.
October 24th. October 24th. We sent it on the 20th. So if you go to the docket, if you go to supremecourt.gov, you'll look at the docket, the filing date. So they file it as they show that it was filed the day you mail it, U.S. mail. So they were able to show that it was filed on the 20th, and they received it on the 24th. So now they notified the U.S. attorneys that the U.S. attorneys have until the 23rd of this month, which is what, 5 days from now? About 5 days from now, the 23rd of this month. They have until the 23rd to file an opposition, to give them a chance to, oppose it. But it's interesting because the Supreme Court asked us basically to put their opposition in the petition. So they could look at this and go, what more could we say? Brunson has already put our motion to dismiss, which is the opposition. So they wouldn't have to file an opposition. So we sent them a waiver too. The court asked us to send them a waiver to see if they want to sign a waiver. So we sent that to them. We haven't heard anything. So they have a deadline of the 23rd of this month. If they don't do anything, then it's like they waive their right to file an opposition. If they respond with an opposition, that just speeds things up. That means that the Supreme Court can now docket it and set a date for conference after we waive our reply or file reply, which we would do immediately.
So what kind of goods are there in this package? Because if I comprehend what you gentlemen did, you put the perfect lawsuit wrapped with a bow with all the tools so SCOTUS can act accordingly. And what kind of actions are there in this case? Because it's not only the actions that you have, but it also, we've been threatened, or they have been threatened about packing the courts. So much more will take place because of your lawsuits. But tell us, what are those actions that are in this lawsuit?
Well, you're absolutely right, and the executive branch and the majority of the legislative branch has fought really hard to do everything they could to destroy the Supreme Court and this conservative justices. To put it in, to simplify it, we have literally handed the Supreme Court on a silver platter the power to remove 385 members of Congress permanently from federal office. Federal, state, and local office. They have the power now to not only remove them, but bar them from holding public office in the United States on any level for the rest of their lives. That's the power we've just handed them, 385. And we've also given them the power with this lawsuit to remove Joe Biden and Kamala Harris with the same restrictions. And Mike Pence is the only federal officer, but they have the power to bar Mike Pence from holding public office the rest of his life. So that's basically the power that they've just been handed with this lawsuit.
Incredible. How do you think the Supreme Court is going to react? You just gave them 388 federal offices or positions to just give them the pink slip.
Exactly. Not just a pink slip. Yeah, but not just a pink slip, like I said.
It goes beyond, right?
Public office, yes. So what do we think they're going to do? Well, that's a good question. All week I think we can go on is the response from the clerk's office, which has been very positive and helpful. We know what they can do. They can do what I just said. Whether they will do that or not, whether they will decide to just let the monetary damages go forward, or a portion of the reliefs that we've asked for in the complaint go forward. But something that's really special about Rule 11, or about an emergency type case, which this is they have the full power, not just to overturn a decision or uphold a decision from a lower court. They have the full power to completely adjudicate, judge the whole complaint, and like you said, address each cause of action. There are 6 causes of action, 6 forms of complaint against every defendant, and they have the full power to grant the reliefs asked for in the complaint. So we're pretty excited about this. We know that there have been other Supreme Court cases that have been in front of them, having related to the voting and the electoral vote problems. And we know that 3 of the justices have voted in favor of those. And now we believe that the other justices, who happen to be Kavanaugh, Gorsuch, and Barrett, that didn't vote for those, are now primed and ready and ripe, I guess is a legal term you could use. They are now ready, I think, and willing to flex the muscles of the Supreme Court majority and to push back in whatever they deem is necessary and feasible. And the way they're going to do it, we don't have a clue. We can just speculate.
Correct. But I think this is incredible. I'm getting even little goosebumps all over, because this is history in the making, sir. And we're very, very grateful. You started this. Now, the lawsuit, let's go back a little bit, because you went a little fast. The lawsuit, actually, there's 2 lawsuits. One that got stuck in the lower courts and still stuck. And that's your, is that your?
That's mine. I'm the plaintiff on that.
On that one.
And my brother's complaint is identical to mine. It's the same lawsuit.
And why did he advance? What was the nuances that were written in order for his case to go forward? Yours got stuck. You have the Third Circuit judge. I think he's an Obama appointee. Appointed.
Well, there are 3. There are 3 judges that make the decision on the circuit court level. And so they know. I think they knew we were going to take it to the Supreme Court. And I don't think they knew that we could bypass their decision. I think they thought that they could just stick it there and have it stay. Now, my brother has a different judge. He has different judges, and that's the only difference. He had different judges, so he was able to move forward.
Now, tell me the story, because you were telling a story about how you present. So your brothers and you all get together, decide to do a lawsuit, decide on what the monetary factors, and then it was during COVID, and because it was COVID, how were you going to serve? And you have a story that the marshals, that actually the courts suggested something really amazing. And I thought, this is divine intervention at some point. I mean, tell us.
Yeah. Oh, yeah, that's a good question. It was very expensive to serve 388 defendants in Washington, D.C. And we found that we couldn't hire a process server because of the COVID, the lockdown, because the Congresses locked themselves down. We couldn't have, the only people that could do it would be the U.S. Marshal Service. So the court told us that because of that was the only way that they would cover the cost of service. So if you look at the federal docket, you'll see that March 31st, I think of 2021, it'll show that Nancy Pelosi and about 80 others were being served by the U.S. Marshal Service as summons and complaint at no cost to us. So that was pretty cool.
Right.
That was my complaint. That was my complaint. And then the judge recalled it and sent a notice saying, oh, this was a mistake by the court, and we didn't mean to do that, and Brunson's complaint is deficient. But so we actually sued the federal court for blocking our case and claiming that my case was deficient. That's another story. We actually sued the federal court and the 10th Circuit Court of Appeals in state court. And after we did that, a few weeks after that was resolved, that we got a notice from the federal court that they had decided to not only allow me to file my case, but they filed it for me, and they ordered the clerk of the federal court to issue 388 summonses. And so within 2 days, we had those summons issued, and that's a case that's still alive, but it hasn't moved forward yet. But so we're just seeing how this goes, but we can move that forward. We're pretty confident that that's just on the shelf, ready to go.
So what happens? Okay, let's move on a little bit. What happens to your case that is stuck in the courts? Supreme Court, SCOTUS has your brothers. Will your case get released, or something will happen that it can move forward? Would that have any effect?
They're identical cases. The only difference would be the monetary awards would be double, because mine we're thinking. So that would be the only difference. So we're not focusing on that. We could, but because we're already at the Supreme Court with the one, we want to wait and see what the outcome of this is before we continue moving the other one forward, which I think we could pretty easily.
Great. So you have handed the power to the Supreme Court,
yes,
to actually do what they were meant to do,
yes,
constitutionally.
They've never had the power that we've just handed them in the history of this country. This is more power than any case has ever granted them. And I think that's why they showed a positive reaction to us through the court clerk's office and asking us if we wouldn't but add more specific things that they had seen from the docket. They have access to all the complaints, so they've been reviewing it, and then they ask us for specific things to be put in it. So it's a lot thicker. It's like about 3 or 4 times thicker than the original one was.
Let's just speculate a little bit, because do you think that this is going to go, that they're going to take action on some part, no action on another part? Are they going to give it to the DOJ? What is it exactly? What would you expect them to do? Because I don't think you have your 6 causes of action. You mentioned a few, but I don't think that you also mentioned that they were going to, you want them. Well, you go ahead and explain it exactly, what those 6 actions.
Well, the way I see it, and we've talked about this a lot, and what I think could happen, we haven't got a clue. It just depends, I think, on how much support they get from this. They could toss it. They could just feel like it's just too big, and I don't know. But no, we think they're going to do something. So what they could do is they could actually, with a court order, require the sergeant in arms to cancel the credentials of the 387 federal officers, including Joe Biden and Kamala Harris. And then they would probably have a team of U.S. Marshals, probably U.S. Marshal Service would probably go in, and they would issue the court orders and relieve the Secret Service from their assignments having to do with protecting the president and the vice president, and just basically give them the papers, the walking papers. And then they would have to figure out how to, replace the president and the vice president. And we've requested that they do certain things, but they could refer to the new House Speaker, or I don't know, we've just
because Pelosi is no longer the Speaker of the House, which that was one of your targets.
So that would be a temporary president while they figure out what to do, I think.
Will the military work?
Then the states would have to figure out how to replace representatives that have been replaced. And some of the new representatives wouldn't be affected by this because they weren't members of Congress at the time. So it'd be interesting. And there were a few members that we didn't sue because they didn't take a vote at all. So we just did the ones that voted against it. Yeah.
All right.
The
So
10-day investigation. We just sued the members of Congress that pushed back and voted against the 10-day investigation.
So it's going to be quite interesting because I don't know, there's a lot of talk in the country right now as to when the military, quote unquote, when the military is going to come in. Is the military ever going to intervene? Because this was a coup. This was, people want to call this a soft coup. And I laugh and I said, no, this was right in front of our face. This was an insult to our intelligence. This was a coup.
It's exactly what they're accusing the Republicans of doing, and we're suing Republicans and Democrats. This is not a partisan thing. This is about participating in an honest and constitutionally sound election. So I think they could, with a court order, they could get the military involved. They could get the National Guard involved if they needed. I don't think that's going to be necessary, but I think once they have the support, and if they feel like they have the support, and then they can flex their muscles, and it'll do the court good. It'll do this country a lot of good. It'll support the Constitution. It'll change the immunity situation that we have with federal, state, and local officials getting away with a lot of dirt because of their immunity. It would compromise their immunity to a great degree.
Right, because this is actually against their immunity. I mean, this is actually to strip them away from immunity.
Right.
Isn't
exactly.
it?
Now, Article 6 of the Constitution requires that all federal, state, and local officials be bound by oath, and you cannot be bound by oath if you have immunity. So it's a constitutional issue that is pretty clear cut. I think anyone can understand that if Congress gives themselves immunity with legislative acts, that when they are supposed to be bound, and they took an oath to be bound by the Constitution because that's part of it. So it's a pretty clear cut case having to do with the Constitution and no immunity. So that's a big part of our case. So we're excited about that.
Yeah, very excited. Very excited. I don't know. I hope that, it's going to be 5 days from now and we'll know something.
Yeah, about 5 days. We should, or sooner, we should at least hear a scheduling for conference. Now they don't even have to do, I mean, they could have conference today. They can do whatever they want. If they feel like it's a timing thing, if they feel like they need to wait, or if they feel that they need to do something immediately, or if they've already done something and the decisions in their, they could have already had a conference. But I think it'll show that it'll go to conference, and we'll just wait and see what happens. Maybe we'll see the news in January where people are having problems swiping their credential cards at the House and Senate buildings.
That would be lovely. What you expect to regarding the judges? What judges you think that may? It's a 4 to 5. 4 to 5.
Well, for conference, it only takes 4 out of 9. So if 5 vote against it and 4 vote for it moving forward, it moves forward. So that's an easier thing to happen in conference. And then finally, we have, who do we have? Clarence Thomas, we have John Roberts, we have Alito that have already voted in favor of Supreme Court cases. They've already voted in favor of challenges to the electoral vote and the vote fraud and shenanigans that happened in the 2020 election. So it's interesting to note that the 3 justices that should have voted in favor with them were Kavanaugh, Gorsuch, and Barrett. The Trump appointed justices. But because now we've seen them act in unison, the 6 of them, in the Roe versus Wade and the fallout that came from that, and the threats and all the horrible things that were said about the justices, we feel like it's ready for the justices to do something to flex the muscles of the court. I mean, the majority of the Congress is threatening to stack the court. Yes. And so I think this is a historical opportunity for the Supreme Court to do something the Supreme Court has never had an opportunity to do before. And I think the legal term is ripe. It's ripe for something really good to happen. So we're keeping our prayers going, and the support is great. It's great that people are talking about it, and we just want people to have a little hope and see if the justices do something that can make a big difference.
Here. I really don't have much to say. I tell you, how exciting, extremely excited to be living in these times. I think this case is glorious. I commend you and your brothers for taking action, because this whole thing about getting we the people is about taking actions from a grassroots level at every single level. And I am so happy to hear that. I hate to say that you had the guts and the ballsiness to do this, because
Well, thank you. We appreciate that. We just were so fed up, and we just felt like we've got to do something. We're headed for a brick wall. So something interesting to note, I think, too, is that when Amy Coney Barrett was being interviewed, she was asked by one of the senators, it was a great question. He said, Senator, just to help people know more about the Constitution, could you please share with us what the 5 protections are in the First Amendment, what rights the First Amendment protects? And what is she? She says assembly, religion, speech, for the press, and she couldn't remember the 5th one. And that's really symbolic, because it's the most powerful one, and it's what we're doing: petition for redress of grievances. And I think that's been so misunderstood. People don't know that they can file lawsuits in federal court, and they're told by the attorneys that you can't, because of their immunity. See, we're not even supposed to be in state or federal court. If we were to sue members of Congress, we're supposed to get permission from the sergeant in arms, get a waiver, go to a special claims court, and not end up at the Supreme Court. But we said, no, we can show constitutional authority, and we can show state and federal constitution clauses that give us a right to go take this to the federal court. So the federal courts accepted us in, and they basically, even with their motions to dismiss, made it possible for us to be where we are now, where it really needs to be, and that's the United States Supreme Court.
Yeah, I looked through your case, and you all 3 brothers did very well. It was smartly put together. You went to the petition for writ of certiorari to the United States. So you then tried the 11th rule, which is really, you're really telling them to investigate, at least to take a look. And so it was well put together, and quite fascinating. And I really, really appreciate what you're doing. And I hope that we put to peace all the nonsense that is happening and has been happening, not just for the last 2 or 3 or 4 years that we've seen, but for decades. I think during Obama's presidency, if we could call that a presidency. That was really, I think that was a downfall. That was definitely the downfall of a lot. You go back to the years preceding that with other presidents, and everything was still questionable. It wasn't as blunt, but when he came, everything was so bluntly in your face, and especially even more so now. But now we the people who are acting and who is participating and doing their best, even in small ways. So I think this is so exciting. So thank you so much, Loy, for coming, sharing your story. And I hear that you also have a book coming, or you don't?
Well, I have a book. I printed 10,000. I have like 10 left. And it's a pocket-sized book that not only has the Constitution, Declaration of Independence, and the amendments, the Bill of Rights, but it also has a guide. It has questions and answers. It's the first publication in American history, this is my claim, that a number of things, but it identifies the power clauses we all need to be aware of that identify and prohibit socialism. It's the first book ever to do that. If you were asked to ask a representative to show you a clause in the Constitution that prohibits socialism, they wouldn't be able to show you a specific clear-cut clause that's right there for everyone to see. And I identify that. That's the last line of the 5th Amendment. And so I explain all that in my book. If people want to help this cause, this case, they can go to 7discoveries.com with the number 7, or they can spell out 7, but 7discoveries.com. We're going to have the petition information there. We're going to have the actual complaint there for at least $1 donation or more. They can download the complaint that this Supreme Court case is referring to. And so, yeah.
Loy, It's a pleasure. I hope you come back. I know you have great other stories to tell, many other anecdotes, and we're here rooting for you, and we'll certainly put the word out of this case in the coming days.
I'd love to come back anytime. Just let me know.
We will. Thank you so much.
Thank you, Susanna. Take care.